The termination letter was printed on company letterhead. I remember noticing that detail in the first second, the logo at the top, the clean institutional font, the way it looked exactly like every other official document Callaway and Dermott Manufacturing had produced in the 22 years I had worked there. Professional. Formal. The visual language of a company that did things correctly. Except that it was Thursday. And my pension vested on Friday. Not next Friday. Not Friday of some future week that existed at a comfortable distance from this one. Tomorrow's Friday. The Friday that was 17 hours away from the moment Patricia Howe, Director of Human Resources, slid that letter across the conference room table toward me with the expression of a woman who had been told to do something she understood was wrong and had decided that doing it was easier than refusing. 22 years. 4 months. 29 days. 1 day short of the threshold. I looked at the letter. I looked at Patricia. I looked at the 2 men sitting on either side of her, Regional Operations Director Glenn Marsh and a man from corporate I had never seen before, whose name I did not catch and did not ask for because I was processing something that required my full attention. Then I looked at the window. Specifically, I looked at the parking lot visible through the conference room window on the 3rd floor of Callaway and Dermott's regional headquarters in Columbus, Ohio. I looked at the row of cars nearest the building entrance. I looked at the gray sedan parked in the visitor spot closest to the front door. And I thought, good. She's already here. My attorney had been parked in that lot for 45 minutes. Let me tell you how we got here. My name is Rosalind Vega Carter. I am 53 years old. I spent 22 years, 4 months, and 29 days working for Callaway and Dermott Manufacturing, a mid-size industrial components company with regional operations in 6 states and a corporate structure that had, over the 2 decades I was there, become increasingly focused on the particular kind of cost efficiency that involves looking at its longest tenured employees and seeing liabilities rather than assets. I started at Callaway and Dermott at 31. Single mother. 2 daughters, Amara, who was 9 at the time, and Della, who was 6. My ex-husband had left the previous year with the consistency of a man who found sustained responsibility inconvenient, and I had spent the months after his departure doing the specific, grinding arithmetic of figuring out how a woman with 2 children and a mortgage could make the numbers work. I had a degree in industrial supply chain management. I had 5 years of experience at a smaller firm that had been absorbed in a merger and shed half its staff. I had skills that were real and a work ethic that was iron and exactly no patience for the version of my life where those things were not enough. Callaway and Dermott offered me a position as a supply chain coordinator at a salary that made the numbers work, barely, if I was careful. I was very careful. Over the following 22 years I was promoted 7 times. Supply chain coordinator to senior coordinator to regional supply chain manager to director of supply chain operations for the Midwest division. I built a department that had, when I arrived, 4 people and unreliable vendor relationships, into a team of 23 that processed over $400 million in annual procurement with an error rate my division had described, in my last formal review, as industry-leading. I was good at my job. I was not modest about being good at my job because I had worked too hard for too long to be modest about it. I had worked through my daughter's childhood, present for everything that mattered, absent for some things that did, carrying the particular guilt and particular pride of a woman who understood that showing them what it looked like to build something real was itself a form of parenting. I had earned a pension. The Callaway and Dermott defined benefit pension plan vested at 22 years and 5 months of continuous employment. It was generous by current standards, a relic of an era when companies used long-term benefits to retain experienced employees rather than viewing long tenure as a cost to be managed. I had known the vesting date for years. I had marked it on my calendar. I had built financial plans around it. It was the difference between a retirement that was secure and one that was precarious. The vesting date was the Friday after the Thursday they called me into the conference room. 17 hours. I want to tell you when I first understood what was coming, because the understanding did not arrive all at once. It arrived the way most important things arrive, gradually, in pieces, each piece individually explainable and collectively undeniable. The first piece arrived 14 months before the termination letter. Callaway and Dermott was acquired by a larger industrial conglomerate called Harwick Group. The acquisition was announced on a Tuesday morning with the language that all acquisitions use: transformative partnership, aligned values, exciting opportunity, commitment to our people. I had been in this industry long enough to translate that language accurately. Costs would be cut, redundancies would be eliminated, and the definition of redundancy would be whatever served the acquiring company's financial interests. I started paying attention more carefully. The second piece arrived 11 months before the termination letter. Corporate sent a consultant, a man named Bradley Foss, mid-30s, MBA from somewhere that had made him confident without making him wise, to conduct what they called an operational efficiency review of the Midwest division. He spent 3 weeks asking questions that were nominally about process but were actually about headcount. He spent particular time with my department, asking about staffing levels and function overlap and whether certain roles could be consolidated. I answered his questions professionally and completely. I also started keeping more detailed records of everything. The third piece arrived 8 months before the termination letter. 2 of my longest tenured colleagues, both of whom, like me, had pension vesting dates approaching in the following year, were offered what corporate called voluntary separation packages. The packages were structured as generous. They were generous if you accepted the framing that the alternative was nothing. One of my colleagues accepted. One did not. The one who did not was terminated 4 months later, citing performance issues that had not appeared in any of his formal reviews in the previous decade. I noted this. I noted it very carefully. The fourth piece arrived 5 months before the termination letter. I had a meeting with Glenn Marsh, my direct superior, about what he described as a reorganization of the supply chain function. He told me that corporate was considering centralizing certain procurement functions at headquarters. He said my role might evolve. He used words like streamline and realign and right size, which are the words people use when they want to describe something damaging in the language of improvement. I asked directly, "Is my position being eliminated?" He said no decisions had been made. I went home that evening. I sat at my kitchen table. I did the math that I had been doing in the back of my mind for months. Then I called an attorney. Her name was Marguerite Hollins. She had been practicing employment law in Columbus for 27 years. She was 60, silver-haired, operated out of an office above a dry cleaner on 5th Street that said nothing about her capabilities and everything about her priorities, which were winning cases rather than impressing clients with real estate. I had found her through a former colleague who had used her during a wrongful termination dispute 3 years earlier. My colleague had described her as the kind of attorney who makes the other side nervous before she said a word, which is exactly what I needed. I told Marguerite everything. The acquisition. The efficiency review. The voluntary separation packages offered specifically to pension-eligible employees. The termination of my colleague after he declined to accept his package. The meeting with Glenn Marsh and his careful non-answers. The approaching pension vesting date. She listened without interrupting. When I finished, she was quiet for a moment. "How long until your pension vests?" she asked. 5 months, I said. She nodded slowly. "Tell me about your performance record." I told her. 22 years of performance reviews, all positive. No formal disciplinary actions. No performance improvement plans. No written warnings of any kind. My most recent review, 8 months prior, had rated me as exceeds expectations in every category. "Do you have copies of your reviews?" she asked. "I have copies of everything," I said. She looked at me for a moment. "Good," she said. "Let's talk about what we do from here. Before we go any further, if this story is doing something to your chest right now, please take 1 second and hit that subscribe button. Tell me in the comments where you're watching from. I read every single one. Now let's keep going because it is about to get very specific. What Marguerite and I did over the following 5 months was build a case before there was a case to build. Not reactively. Proactively. With the understanding that the best legal position is one established before the adverse event, not after. Here is what we documented. Every performance review for 22 years, copied and organized chronologically. The reviews established a clear and unbroken record of strong performance with no negative indicators at any point. The pension plan documents, the summary plan description, the vesting schedule, the formal terms under which my pension would become non-forfeitable. These established exactly what I was entitled to and exactly when. The timeline of the voluntary separation packages, including the names and pension vesting dates of the colleagues who had received them. This established a pattern. Employees close to pension vesting had been systematically targeted for separation. Communications relating to the so-called operational efficiency review, including emails I had sent and received, meeting notes I had kept, and a detailed written account of my conversation with Glenn Marsh that I had drafted within 24 hours of that meeting while the details were fresh. Marguerite also conducted her own research. She pulled Harwood Group's public filings and found 2 previous acquisitions in the preceding 6 years. In both cases, she found evidence of similar patterns, mass terminations of long-tenured employees in the months preceding pension vesting dates. In one of the prior acquisitions, a class action lawsuit had been filed and settled confidentially. "This is not the first time they've done this," she said. "I know," I said. "Which means they know how to do it in a way that looks clean. Which is why we need to be cleaner." She looked at me with the expression of an attorney who has found the client she was hoping for. "Exactly," she said. "We established, between us, what Marguerite called a trigger protocol. If I was called into any meeting with HR or senior management, any meeting at all, I was to send her a specific message from my phone before entering. She would drive to the office and park in the visitor lot. She would wait. If the meeting produced a termination, I was to request a recess to consult with counsel. I was to walk out of the building, speak with Marguerite, and not sign anything until she had reviewed it. We had rehearsed this multiple times. Over 4 months of preparation, we had rehearsed exactly what I would do if the moment came. When the HR assistant called my office on a Thursday morning and said Patricia Howe would like to see me at 2 o'clock, I had already sent Marguerite the message before I put the phone down. She responded in 4 minutes, "On my way." I finished the work I was doing. I ate my lunch. I walked to the conference room at 2 o'clock, and I sat down across from Patricia Howe and Glenn Marsh and the man from corporate, and I kept my hand still in my lap. Patricia slid the termination letter across the table at 2:07 in the afternoon. She explained, in the careful language of a woman reading from a script that legal had approved, that due to a restructuring of the Midwest Division's supply chain function, my position was being eliminated effective immediately. She said Callaway and Dermott appreciated my 22 years of service. She said there would be a severance package. She said the details were in the folder in front of me. She did not look at my face while she said any of this. Glenn Marsh looked at the table. The man from corporate had his phone in his hand. I let the room stay quiet for a moment after Patricia finished. I had learned, in 22 years of supply chain management, that the silence after a presentation tells you more than the presentation itself. Then I said, "I'd like to take a few minutes to review this with my attorney before I respond." The specific quality of stillness that entered that conference room in the 2 seconds after I said that sentence is something I will remember for the rest of my life. It was the stillness of 3 people who had prepared for a difficult conversation and had not prepared for this particular development. Patricia recovered first. "Of course," she said. Her voice was careful. "Can I ask, you have an attorney present?" "She's in the parking lot," I said. "I'll just be a few minutes." I picked up the folder. I walked out of the conference room. I took the elevator to the lobby. I walked through the front doors of Callaway and Dermott Manufacturing's regional headquarters into the October afternoon. Marguerite was leaning against the passenger side of the gray sedan with her arms crossed and her briefcase on the hood of the car. She looked like a woman who had been waiting comfortably, which she had been. I handed her the folder. She opened it. Read in silence for approximately 4 minutes, which is a long time when you are standing in a parking lot in October knowing that 3 people are sitting in a conference room on the 3rd floor watching the clock. Then she looked up. Effective immediately, she said. 22 years, 4 months, 29 days of service. Pension vesting date tomorrow. Yes. The severance package is 3 months. She closed the folder. They're offering 3 months of salary to walk away from a pension worth significantly more than that. How much more? Marguerite had run the numbers 6 weeks earlier, when we had anticipated this scenario. She told me the estimated present value of my defined benefit pension given my salary trajectory, projected retirement age, and actuarial life expectancy. The number was substantial. I do not want to give you the precise figure because some of what followed became part of a legal matter with confidentiality components, but I will tell you that 3 months of salary was a small fraction of it. A very small fraction. What do we do? I asked. She looked at me. We go back in there. And I do the talking. We walked back into Callaway and Dermot's regional headquarters together. I want to describe Marguerite Hollins in that moment because I think it matters. She was 60 years old, silver-haired, 5 feet 4 inches tall in flat shoes. She was wearing a dark blue suit that had seen significant use and a pair of reading glasses on a chain around her neck. She carried a briefcase and a legal pad and the particular energy of someone who has spent 27 years knowing exactly what she is doing. She signed in at reception as Marguerite Hollins, attorney at law, counsel to Rosalind Vega Carter. The receptionist called the conference room. I watched his expression shift slightly as he relayed the information. He hung up and told us they would be with us in a moment. They were with us in less than 90 seconds, which told me they had made a phone call to someone above Glenn Marsh in the time I had been in the parking lot. When we entered the conference room, Patricia Howe was still there. Glenn Marsh was still there. The man from corporate was still there. And there was a 4th person now, a woman I did not recognize who introduced herself as corporate counsel. Marguerite introduced herself, shook the corporate counsel's hand with the warmth of a professional who has nothing to hide and everything prepared, and sat down. I sat beside her. What followed was a conversation I was largely not party to, in the sense that Marguerite conducted it and I watched. This had been our plan. She had told me, in 4 months of preparation, that my job in that room was to say nothing unless she indicated I should. That the power in the room came from our documentation and her legal knowledge and my silence, and that all 3 were essential. Marguerite opened her legal pad. She noted, precisely and without drama, the following. That my employment had been terminated effective immediately, 1 day before my pension vesting date, after 22 years of documented strong performance with no negative performance indicators. That 2 other long-tenured employees with approaching pension vesting dates had been targeted for voluntary separation in the preceding 8 months. That 1 employee who had declined a voluntary separation package had subsequently been terminated with performance justifications inconsistent with his formal review history. That Harwick Group had engaged in similar patterns in at least 2 previous acquisitions, one of which had resulted in litigation. That the Employee Retirement Income Security Act, ERISA, specifically prohibits the termination of employees for the purpose of preventing pension vesting, and that the pattern she had described, combined with the specific timing of my termination, constituted evidence of exactly that prohibited conduct. That she was prepared to file a complaint with the Department of Labor's Employee Benefits Security Administration the following morning if this matter was not resolved to her client's satisfaction today. The corporate counsel was quiet through all of this. Glenn Marsh was very still. Patricia Howe was looking at the table. When Marguerite finished, the corporate counsel asked if she could have a brief recess. Marguerite said of course. We stepped out. They called someone. I could see through the glass door the posture of people on a conference call with someone they were accountable to, the specific body language of individuals who have just realized the situation is larger than they'd been briefed. The recess was 11 minutes. When we went back in, the tenor of the room had changed in the specific way that rooms change when a decision has been made above the level of the people sitting in them. The corporate counsel spoke. She said that Callaway and Dermot wished to revisit the terms of the separation. She said they acknowledged my long service and my contributions to the company. She said they wanted to reach a resolution that was fair to all parties. Marguerite looked at her notepad. My client's pension vests tomorrow, she said. The most straightforward resolution is one that allows that to happen. I am going to be careful here about what I tell you, because the specific terms of what was resolved that afternoon and the subsequent formal agreement are subject to confidentiality provisions that I am not going to violate. What I can tell you is the shape of what happened. We were in that building until 6:37 in the evening. 4 hours and 30 minutes. Multiple recesses. Multiple phone calls to people above the level of the people in that room. Marguerite and the corporate counsel, at a certain point, conducted a portion of the negotiation in a separate room while I sat with Patricia Howe in a silence that was not uncomfortable so much as honest, the silence of two women who understood exactly what had been attempted and what it had cost. Patricia said, at one point during that silence, I didn't make this decision. I know, I said. I'm sorry, she said. I looked at her. I know that too. We didn't say anything else. What I can tell you about the resolution is that I did not walk out of that building having lost my pension. I did not sign the 3-month severance and walk away from 22 years of earned benefit. The documentation Marguerite had assembled, the pattern she had identified and articulated, and the specific legal framework she had invoked, ERISA, the Department of Labor, the prior litigation, created a situation in which proceeding with the termination as structured was significantly more expensive for Callaway and Dermot than the alternative. Companies do not make decisions based on what is right. They make decisions based on what is costly. Marguerite understood this completely and had structured everything accordingly. I left that building at 6:37 with an agreement that protected what I had spent 22 years building. My attorney walked me to my car. You did everything right, she said. You did everything right, I said. She shook her head. You came to me 5 months before. You had every document. You anticipated every move. I showed up and presented what you had built. A pause. I've had clients come to me after. I've had clients come to me with nothing. You came to me with everything, before it happened. I looked at the building behind her. 22 years of early mornings and late deliveries and vendor negotiations and supply chain crises managed and department culture built. 22 years of showing up. I'd been in supply chain management for 22 years, I said. You identify the risk before the disruption. You don't wait for the shipment to fail to figure out you needed a backup supplier. She laughed. The real kind. Go home, she said. Rest. I drove home. I want to tell you what happened in the months after. I did not stay at Callaway and Dermot. I want to be clear about that. The agreement that was reached made remaining possible but did not make it desirable. I had spent 22 years in that building and I knew, in the way you know things about your environment when you have been in it long enough, that the culture that had produced that Thursday afternoon was not going to change because of one afternoon's negotiation. I had a pension now. I had protection. I had the runway I needed. I left 6 months later, on my own terms, with the formal retirement paperwork filed and the pension calculations confirmed and a goodbye lunch that filled the conference room with people from all 7 promotions worth of career. Amara flew in from Portland. Della drove from Cincinnati. They sat at the front of the room and watched me stand at the head of the table and I looked at them, these women I had raised in the margins of 22 years, and I thought about the Tuesday morning when Amara was 9 and Della was 6 and I had walked into a job interview at Callaway and Dermot because the numbers needed to work and I had needed them to work. They had worked. Not easily. Not without cost. But they had worked. Here is what I did after I left. I had, in the months following that Thursday, been contacted by 2 other former Callaway and Dermot employees with approaching pension vesting dates who had either accepted voluntary separation packages or been terminated and who, after hearing through informal professional networks that I had navigated a different outcome, wanted to understand what options they had. I connected them with Marguerite. One of them had a viable case. One did not. She had signed her severance agreement without consulting an attorney, which made her legal options significantly more limited, though not entirely closed. The one with the viable case filed. The case settled. I cannot tell you the terms. I can tell you that she now has more than she was offered the morning they handed her the folder. The larger pattern, Harwick Group's conduct across multiple acquisitions, attracted attention. I do not want to overstate my role in that. I was one data point. But data points accumulate, and the Department of Labor's Employee Benefits Security Administration is an agency that, when it identifies systematic ERISA violations, investigates them. Investigations take time. I will not tell you that everything was immediately made right, because it wasn't. I will tell you that the machinery of accountability, once engaged, does not stop simply because it moves slowly. Here is what I want you to know. ERISA, the Employee Retirement Income Security Act, was passed in 1974 specifically to protect workers' pension rights from exactly this kind of conduct. It is a federal law. It has teeth. It prohibits employers from firing employees to prevent pension vesting. The burden of proof in these cases shifts once a pattern is established. Once you can show that the timing of a termination is suspicious, the employer must demonstrate a legitimate non-pretextual reason for the termination. The key phrase is, you must be able to show the pattern. Which means documentation. Which means starting before the adverse event, not after. I had 22 years of performance reviews. I had the pension plan documents. I had the timeline of what had happened to my colleagues. I had contemporaneous notes from my meeting with Glenn Marsh. I had an attorney I had retained 5 months before the termination letter landed on the table. None of that was complicated. None of it required special resources or unusual sophistication. It required attention and patience and the understanding that the people who end up protected are the people who treat their professional lives like the serious legal and financial matters they actually are. My mother worked for 30 years at a textile company in Greensboro. She was laid off at 58, 3 years before her pension would have vested, in what I understood only years later was almost certainly the same playbook. She signed her severance agreement the day they handed it to her. She spent her retirement on Social Security and what she had managed to save. I thought about her on that Thursday afternoon. I thought about her every time I sat down with Marguerite over those 5 months. I was not going to be the generation that signed the folder. My daughters call me every Sunday. Amara from Portland, Della from Cincinnati. We talk about ordinary things, their lives, their work, the small accumulating detail of being a family across distances. Sometimes they ask about what happened at Callaway and Dermot. Della calls it the showdown. Amara calls it the parking lot story, because that was the detail that got her, the image of Marguerite leaning against the gray sedan, waiting. I have told them both, more than once, document everything. Know your rights before you need them. Find out where your pension vests and when. Build the file before the crisis. Della is 31 now. She is 4 years into a corporate job that has a pension plan with a vesting schedule she can recite from memory because I asked her to read the plan documents the week she started. She called me the month after she started and said, "Mom, I read the pension documents." "Good," I said. "The vesting cliff is at 8 years, she said. "Then you start keeping records now," I said. She was quiet for a moment. "How do you know when to start worrying?" she asked. "You don't worry," I said. "You prepare." There's a difference. Worry is reactive. Preparation is what you do before anything happens, so that if it does, you're already ready. A pause. "Like having the attorney parked outside," she said. "Like having the attorney parked outside," I said. "My name is Rosalind Vega Carter. I am 53 years old. I spent 22 years building a career at a company that attempted, one day before my pension vested, to take what I had spent those years earning. They slid a folder across a conference room table. I picked it up. I walked to the parking lot. And my attorney was already there. That is not luck. That is not coincidence. That is 5 months of patient, specific, documented preparation by a woman who learned from her mother's story that the only thing that stands between you and the people who want to take what you've built is the work you do before they try. Do the work. Keep the records. Find your attorney before you need them. And know exactly what your pension is worth, because the people on the other side of that conference room table always do. Thank you for staying with me through every minute of this story. If it gave you something, a reminder to read your benefit documents, to document your performance record, to find out what protections exist before you ever need to use them, then telling it was worth every word. More stories are waiting on your screen right now. Click 1. I'll meet you there.